Well, I'm back. It looks like there was a video of me the last time, and the file's big, and I have to get Campus to upload a new thing to the Moodle account to allow for posting of a larger file, but that should happen in a couple of hours. So in the meantime, I'm just going to continue on and finish up with the courts. This should be relatively short. We covered the district courts and how many there are in the last lecture before we left. We reviewed the map of the federal judicial districts. We discussed how many courts of appeals there were in the United States. Primarily, these judges hear cases that are appealed from federal district courts. Remember, the district courts are criminal courts. These are appellate courts. And they hear about 60,000 cases per year. They're a major part of our judicial system, and those appeals go to the U.S. Supreme Court. Another picture of the circuits. We're up here in a New England circuit. Vermont and Connecticut somehow ended up with New York. We talked about the Supreme Court last time. We talked about checks and balances on the court. Here's a pretty good video of this. The president appoints the judges, but the Senate has to approve the judges. Congress can organize the court system, and the courts can rule on executive orders. They can also rule on legislation, whether or not it's constitutional. So there is a system of checks and balances in place. Now, that doesn't mean when we ever talk about checks and balances, it doesn't mean in any sense that they always work all the time the way they should. At any given point, things are probably out of balance. But you hope that the system continues to strive to correct itself to one degree or another. Just by way of example, let's talk a little bit about how the court interacted with the president over the issue of immigration. You probably remember executive order blocking immigration and travel from 7 Muslim-majority nations that started in January of 2017, which seems like an absolute lifetime ago. The president expressed a concern relating to terrorism, issued Executive Order 13769 that lowered the number of refugees to be admitted to the United States. It suspended the U.S. refugee admissions program. It suspended the entry of Syrian refugees indefinitely. And it directed cabinet secretaries to suspend entry of individuals from Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen for 90 days. It also prioritized refugee claims made by victims of religiously based persecution. The courts responded by striking that down, that this is the Ninth Circuit Court of Appeals. So remember, there's a lot of different courts of appeals. This is just one of them. And they said that the government provided no evidence that foreign nationals from those 7 countries had perpetrated any terrorist attacks on U.S. soil. In fact, they used President Trump's own words against him by regarding his stated intent to create a Muslim ban, which to the court, the Ninth Circuit Court, suggested religious discrimination. So there's a court striking down an executive order as unconstitutional under the First Amendment. They then went back to the drawing board and issued a second executive order with some key differences from the previous one. First, they took Iraq out. Secondly, they said Syrians were no longer banned indefinitely. Third, they no longer prioritized Christians for exceptions. They then said visas that are already issued would be accepted and that permanent U.S. residents were not included in the ban. A few other exceptions were made as well. And I think they might have added Venezuela to that list. Again, in May of 2017, now the Fourth Circuit Court, so this is not the Ninth, but the Fourth, said that the travel ban drips with religious intolerance, animus, and discrimination in violation of the Establishment Clause. Again, they used Trump's words against him regarding his statement that he wanted to create a Muslim ban. The Ninth Circuit, to go back to them, also said the president recently confirmed his assessment that it is the countries that are inherently dangerous rather than the 180 million individual nationals of those countries who are barred from entering under the president's travel ban. It's interesting to see President Trump's words used in court cases in almost real time. And then Trump said again, that's right, we need a travel ban for certain dangerous countries. That's some politically correct term that won't help us protect our people. So he's trying to back off a little bit on using the word Muslim ban. He then proclaimed 9645, a third version of the travel ban in September. Again, some key differences. He did add Chad, North Korea, and Venezuela. Maybe then he could argue that it wasn't necessarily a Muslim ban. They removed the Sudan, and they described new procedures for issuing visas and vetting entries into the United States. This time it went to the Supreme Court, and the Supreme Court allowed the ban to take effect until the case has been fully litigated. In December of 2017, the Ninth Circuit Court of Appeals upheld the injunction on the ban, but it remained in effect per the Supreme Court's order. So the Supreme Court did approve it, and then the Supreme Court did uphold it by a ban of 5-4. So you see in this a little bit of the workings of the court system, how it worked through the appeals, how it finally got to the Supreme Court. In this case, the president had to change the wording of the ban 3 times, and after 3 times, the Supreme Court upheld it by a 5-4 vote, which again reflects the conservative majority of the court. They argued the president has broad authority to protect the nation's borders, and this authority was not undermined by the president's inflammatory comments about Muslims. Similar, so during World War II, with the liberal dissenters, compared the discussion to Karematsu versus the United States in 1944, which upheld the detention of Japanese Americans during World War II. So that is a good illustration, I think, of the court system, how it works, how it worked with a particular issue. The next thing I'm going to do is I'm going to move on, and I'm going to talk about freedom of press, and especially I'm going to talk about freedom of speech regarding what we would call fighting words, which would be starting in the next lecture. So the next lecture is going to talk a little bit about freedom of the press, a little bit about libel, and move on to the concept of fighting words. I leave you with the thought regarding fighting words. Essentially, the United States has almost an absolute freedom of speech. There is no such thing as hate speech in the United States. It's not a law. There are in other countries. And the court generally rules in the United States that people do not have a right to not be offended. Is that right or not? And I think that's something to think about for the next talk.